Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about lengthy trials. Cases that should have gone to the Supreme Court of Canada, but didn't. Robert Amato was charged as a co-conspirator in a number of other offenses with a number of other individuals. He had a lengthy trial, but most of the proceedings were occupied by a bunch of arguments related to the other individuals that didn't impact him specifically and that he wasn't advancing. He essentially was made to be along for the ride, wading through all of these arguments and waiting for the opportunity to have his case determined on the merits. Once his case was heard, he was found guilty, and he argued at trial that his sentence should have been reduced on the basis of the fact that he had to endure lengthy proceedings that weren't necessary, given the fact that the information that delayed the proceedings had nothing to do with him. The court disagreed and refused to reduce the length of his sentence, claiming that the length the trial took place was not a factor that could impact the decision on sentencing. This case obviously raises important issues because, as the Supreme Court of Canada has made clear in cases like Jordan and Cody and the continuing line of cases that come from the court, counsel always need to be cognizant about the amount of time that proceedings are taking and take reasonable steps to shorten proceedings in order to minimize the inherent prejudice to an accused individual. A lengthy proceeding that has nothing to do with somebody who is a co-accused on an information is necessarily prejudicial to that person. It delays that person having their case determined in court and having their trial heard on the merits that affect them. And if the Crown prosecutors make decisions to join charges together and to join accused together in informations that name multiple individuals and multiple charges, then Crown prosecutors need to think clearly about what is actually necessary and sever charges where appropriate so that different trials can be held on different issues, even if some evidence may have to overlap. In situations like this, it will reduce the delay for some of the individuals before the court, while not significantly adding to the delay for the other individuals. And so doesn't it make better sense in protecting the rights of an accused person to be tried within a reasonable time, not to make them sit through days and days and days of court proceedings that have nothing to do with them? And how is it in the interests of justice to require a person who might otherwise be out in the community working or attending an educational institution or attending a rehabilitation facility to sit through trial that has nothing to do with them instead of participating in those activities? All of this seems to be contrary to the ultimate goals of our justice system, and yet the notion that a person should even benefit from a reduction in sentence or have it considered as a mitigating factor in sentence, the length of the trial that they had to endure for things that had nothing to do with them, to me seems absurd. It doesn't seem in keeping with the rest of what the Supreme Court of Canada has said about delay and about needing to minimize delay and about taking better steps to compensate for delay which is excessive and unnecessary. And unfortunately, the Supreme Court of Canada here missed an opportunity to deal with a case that really would have made the playing field more fair and might actually help to continue to alleviate the burden on the justice system of lengthy trials that don't need to take as long as they do, clogging up the wheels of justice. Unfortunately, it will take other cases where other accused individuals have to wait around while other people who are charged on the same information as them make arguments that don't have anything to do with the charges those people are facing before the Supreme Court of Canada has another opportunity to hear this. And that is a real strain for the whole justice system. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada But Didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.